of Ghana, Nana Adodankwa Akufo-Addo. Please, the petitioner, that Samuel Osuampofo, my lord. Sorry. Jane Mensah, my lord, chairperson, represents the first respondent. Mr. Peter McMahon for the second respondent.
If your lordships please appear for the petitioner applicant.
May it please my lords, Justin Amenvo appears for the first respondent with Alexander Samoa.
Please, your lordships, Akutuampa for the second respondent. My lords, with me are my learned friends, Frank Davis, Request Referee, and Yao Pong.
My lords, we actually had two applications. My understanding is that the application for review is the one that will be heard by this bench. Now, the application for stay will be for the ordinary, so to speak, panel. Yeah, there you go. So, my lords, I take it therefore that we are here for the application for review. And at some point, we will do the application for stay of proceedings as well. Very well.
By way of case management, please can we give you about 30 minutes to...
I'm sorry.
I said by way of case management, we want to manage the time. So we will limit each lawyer to 30 minutes. You can finish earlier, fine. If it turns out that you also want some more time, you can also add some a few minutes to it.
Very well, my lords. Before I even move our application, again, just for the record, we did request your lordships respectfully to start today's proceedings at 11:30, and I do want to say that we appreciate the fact that your lordships acceded to that, because we received their processes. My learned friend, my learned junior, received the process at about 11:13 p.m. last night and forwarded it to me by email as well. And at that time of night, I'm not normally. So we appreciate the fact that your lordships granted the indulgence of hearing the matter at 11:30. Very well. Very well. We're grateful for that indulgence. My lords, I respectfully move in terms of the motion paper and the supporting affidavit. my lords, it needs to be absolutely clear that this review is in respect of your ruling of the 11th of February. And I seek to make it clear from the onset because as will be clear in my submissions, the affidavit in opposition of counsel for the first respondent makes references to a ruling of yours on the 16th of February and so on. But this application before you currently is in respect of your ruling of the 11th of February. And my lords, it is important also to indicate the difference between the matters that arise in the context of that ruling as against the matters that arise in the context of your ruling of the 16th February. It's important to make that clear from the onset in order to avoid any confusion in anybody's minds. Because, my lords, in respect of the application before you and the ruling that your lordships gave on the 11th of February, we are dealing essentially with what happened in court when, after we closed our case, the respondents announced certain steps that they sought to take. And in announcing those steps, my lords, they made explicit reference to two rules of court. They made explicit reference to Order 34, I'm sorry, Order 36. Order 36, 4. 36, 4, 3. They made explicit reference to that, and they also made reference to Order 38, Rule 3E5. Those were the two orders, the two rules of court that they referred to. Nothing else, my lords, nothing else. No reference whatsoever was made to Order 38, Rule 3E1 by the respondent, by counsel for the respondent, when they put their positions before you. And in our response, we sought, my lords, to indicate why, based on those rules, it could not be the case that the chairperson of the first respondent, whose witness statement was already before you, and who had deposed to affidavits in which her availability to be cross-examined was clear and unambiguous. We sought to indicate that that availability to be cross-examined could not be curtailed by the position that was now being taken at the time. And my lords, we are perfectly familiar with rules about what a plaintiff must do to establish their own case and all that. We are perfectly familiar with those rules. But the matter that was before this court at the behest of the respondents had to do with Order 36, Rule 4.3, and of CI 47 and Order 38, 3E5, I'm sorry, 3E5. Of CI 47 as amended by CI 87. And my lords, it was our submission that the respondent, the first respondent's chairperson, was stopped from now refusing to subject herself to cross-examination, as she had deposed to in affidavits before this court. That was our submission. There was never any claim on our part that a party cannot call evidence if they don't want, and so on. That was never part of our submission. But those are very trite matters of law, which we are familiar with. Our submission was in respect of a particular witness who had not only filed a witness statement, but who had made sworn depositions before this court. Sworn depositions before this court. And that is why ground A of our grounds for review make clear that your lordship's ruling, which made no reference whatsoever to section 26 of the Evidence Act 1975, that ruling was per incuriam, that provision of the law. Your lordships made no reference whatsoever to that. That's clear on the face of the ruling. And there's obviously no argument about that. The issue of estoppel was actually raised from the bench in the course of my submissions. And I made clear that we were relying on an estoppel. And my lords, our submission is that we cannot just treat lightly the depositions that have been made on oath by the chairperson of the first respondent. We cannot treat them lightly because the Evidence Act is clear about the effect of those depositions. The Evidence Act is very clear in its terms. Except as otherwise provided by law, including a rule of equity, when a party has, by his own statement, act, or omission, intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceeding between that party or his successors in interest and such relying person or his successors in interest. And my Lord, the nature of a conclusive presumption is provided for in section 24, where the basic facts that give rise to a conclusive presumption are found or otherwise established in the action. No evidence contrary to the conclusively presumed fact may be considered by the tribunal of fact. Conclusive presumptions include but are not limited to those provided in section 25 to 29. So clearly 26 falls within what is determined as conclusive presumption. And so what we were urging on your lordships was clearly covered under section 26. And our submission is that your lordships made no reference whatsoever in your ruling to that section, and that decision is per incuria. And my lords, we also in ground B make reference to the fundamental error in our respectful submission. The fundamental error of failing to appreciate how the crucial constitutional role of the chairperson of first respondent necessitated her being called upon to testify and has occasioned a grave miscarriage of justice to the applicant. And my lords, we are not saying that the Electoral Commission and its chairperson are to be subjected to different rules of procedure or different laws. We are certainly not saying that. In fact, what we're saying is that they should be subjected to the same laws that other Ghanaians are subjected to, including Section 26 of the Evidence Act. And we're saying furthermore that in addition to the fact that she has made these depositions, we have here a situation where her conduct, because of the constitutional assignment given to her, where her conduct in the exercise of those constitutional responsibilities is an issue. That is the heart of this matter. Her conduct in
Excuse me, please, are you addressing us on
ground B?
Ground B?
Yes.
Oh, okay.
Her conduct in making a declaration on the 9th of December, her conduct is at the heart of this matter. And that conduct according to the answer to the petition that we have filed, that conduct has been admitted to be flawed. The answer to the petition acknowledges that her declaration was flawed. The answer of the respondents to the petition acknowledges that her conduct was flawed. Her conduct was flawed, and attempts were being made to correct that conduct. And those attempts were in the nature, as it turned out, of some unsigned press releases that came from the first respondent's office. Unsigned press releases which did not by any measure amount to a declaration or a rectification of a declaration that has been made. Those unsigned press releases could not conceivably have that effect. More so because what the answer acknowledges to be flaws, which were purported to be corrected on the 10th by the unsigned press release of the first respondent, that correction itself is different from what the answer now claims to be the correct results. So you have a declaration with certain data. On the 10th, an unsigned press release says there was an inadvertent error. An unsigned release. We don't know who issued it. We have no idea whether it was even issued on her authority. But the unsigned press release says she, the sole person with the prerogative, she made an inadvertent error. And that press release gave certain figures in respect of the inadvertent error. Those figures are themselves different from the figures that are the basis of the answer that has been put before you. An answer which has been verified again by her affidavit. The same chairperson verifies an answer whose figures are different from the correction that was supposed to have been made on the 10th of December, which again she seems to be acknowledging to be relevant to her case or to the case of the first respondent. My lords, this is the situation that we find ourselves in this particular case. And it is for those reasons specifically that we sought to insist that the conclusive presumption in relation to her ought to be given effect such that she would testify about matters which are within her sole prerogative. Nobody else in the world is in a position to address those matters other than her. So that, my lord, is the import of our reference to her constitutional duties. We do not say that she should be made to be subjected to different procedural rules. That is stated in your ruling, but frankly, my lords, I do not know what part of our submissions that is meant to be related to. But we are simply putting to your lordships the nature of her responsibilities tied to our ground A, her own depositions, her own affidavits verifying an answer, and the inconsistencies between all these matters. Now, my lord, in any normal case, which didn't have even to do with an election, in any normal case, a trial judge would be within his rights, even under the Courts Act, to summon a witness. A trial judge would be within his rights to do that. But, my lords, we considered that the circumstances that were before you, based on their own conclusive presumption, made it appropriate at that point for there to be a ruling that she should testify and therefore be subject to cross-examination. My lords, I'd like to deal with grounds D and E before I finally deal with ground C. D and E. Yes, I will first deal with ground D. And my lords, in your ruling of the 11th of February, there was an indication from your lordships that the authority of Sumaila Bilbil and Adamu Dramani, that authority could be distinguished. And under ground D, our respectful submission is that what your lordships stated in seeking to distinguish that earlier decision, what your lordship stated did not reflect the ratio decidendi. The reason for that decision. Our submission, respectfully, is that the reason for that decision and your lordship stated at page 7 of your ruling as follows. Indeed, the distinction between that case and the current case is clearly demonstrated by the ruling of Dr. Dateban, Justice of the Supreme Court, and your lordship's quote, "It is a unanimous view of this court that the first defendant should be called upon to open his defense in the interest of justice." And then your lordships go on, and I believe the underlining or the emphasis must be from your lordships, because your lordships go on to underline a portion of that decision. The procedure before this court is such that before the commencement of oral testimony in this case, the first defendant had already put matters in evidence by affidavit. In this circumstance, it is artificial and hardly sustainable to disregard the evidence already adduced by the affidavit of the first defendant and proceed to an assessment of a no-case submission made on his behalf, as if the evidence on record is that of the plaintiff. Our submission is that The ratio decidendi of this decision is actually in the first sentence of the paragraph that your lordship quoted. It is a unanimous view of this court that the first defendant, Adamu Dramani, should be called upon to open his defense in the interest of justice. That is the ratio decidendi of that decision. In the interest of justice. Because, my lords, in those circumstances that were then described in the passage that your lordships have underlined, the court in Sumaila Bilbil sought to demonstrate why it was in the interest of justice that that defendant should be called upon to testify. And my lords, it is precisely the interest of justice that we consider the interest of justice in respect of have to do with different factual circumstances, but the principle that is at stake applies to this set of facts as well. Because this set of facts includes a conclusive legal presumption against her. Now,
what is your formulation of the ratio in Adamu's part? What formulation?
Testify. Now, my lords, it is suggested that, and I can't remember which of the respondents, I think the first Respondents' Council in their response, they suggest that even if your lordships did not, you know, follow or did not, if you made an error in respect of the ratio decidendi, they claim that in any case your lordships can always depart from your previous precedents. That essentially is the argument that I have read, I think, in the statement of case of counsel for the first respondent.
Mr. Secretary, your 30 minutes is up.
I'm sorry.
The 30 minutes is up.
Well, my lord,
I'm keeping the time.
I'm sorry.
I'm keeping the time.
He's the official timekeeper.
Okay.
So if you want to,
My lord,
if you want to wind up,
I think I'm 3/4 of the way through. My lord, sometimes timekeepers, they stop the clock when there are questions, but I don't know if that is your practice. So, very well. My lord, I will shortly be done. I will shortly be done. I know we have some international football officials in court, so we have to be very careful on these matters. But my lord, respectfully, that claim that your lordships can just depart from your previous decision, that claim is not consonant with what the Constitution provides. What the Constitution provides is that you may depart if it is right to do so. That's very clear. So why do they just that you may depart without quoting the full provisions which says you may depart if it's right to do so? And my lord, my understanding of those provisions, therefore,
Mr. Chikasa, we have not said, we didn't say we are departing. So you can, it is the formulation of the ratio which is
yes, my lord, you did not say so. I'm responding
we did not say we
I'm responding to what they have said. Very well, very well. I wouldn't have known that if I hadn't put forward my argument. Very well, very well. So my lord, basically, we are submitting that the ratio decidendi is how the interests of justice must prevail, and those interests of justice, when tied to the circumstances that we have here in our respectful submission, those interests, the interests of justice in this case, given all the circumstances that we've alluded to, justify or require the chairperson to be called upon to testify. And that has nothing to do with whether a party can be compelled to testify or not. We are not. We know that the party cannot be compelled to testify, but we respectfully insist that we must distinguish the role of a witness from the role of a party. And some of the authorities that your lordship cited are in fact very clear on that distinction between the role of a party and the role of a witness. So my lord, in this case, we are talking about a witness. And we are talking about a witness who is
My lord, with all due respect, matter in the affidavit or in the argument which relate to this in the party. I don't see that. So I don't think that should be permitted to advance those arguments. Yes. No, my lord, if it is not part of his argument, the court, with all due respect, should not allow him to be introducing new things so that we go along forever. That's my point. This is extraneous to his application.
My lords, what I'm arguing is not at all extraneous. Your lordship cites a number of decisions, and I will come to those decisions, because in those decisions, including, I believe, Nyamiche and
My lord, I need to come back again. The court may have cited some decisions that he disagrees with. It is not part of this application, so he cannot be referring to it, because the review application will be judged on the grounds. He cannot use the review application to open a door. My lords, again, the public is listening to these, submissions. No, the public is listening to these submissions, and if counsel is saying something that he ought not to be saying, he should not.
My time. I think the clock,
Order.
Is wasting.
Order in court, please.
My Lord said in your ruling at page 8, in Yamicha and Pierre J, as he then was, delivered at page 8, the plaintiff contended that since the first defendant did not give evidence, judgment should have been entered against him. I do not agree. A party to an action need not give evidence himself. That is from a ruling of this court. And that is part of the justification that your lordship gave to that ruling. Why am I not entitled before you that I cannot comment on something? Yeah, but my lord, it is an absurd proposition.
Let us lose focus on what we are doing here. Yes, please. There was an objection from counsel, and we have allowed you to proceed. So, out of respect, let's be.
Of courts frequently, and I can cite many authoritative articles of certain learned professors which say that a certain decision, So, my lord, if I may just continue with my submissions. In Barron and Labby, a party to a suit is not bound to give evidence, and the court cannot compel him. No, my lords, I mean, if these judgments are not relevant to what your lordships were deciding, it's not evident on the face.
Mr. Chikasa, I think you've lost me a bit. What's the distinction you are drawing here?
Between a party and a witness.
And a witness for a party. Are you asserting that the cases that were cited referred to parties and not witnesses? Is that the submission you're making?
My lord, I didn't make that submission.
I'm trying to understand you. Could you kindly...
Yes, my lord, the submission I made was that we had not claimed that we were contesting the principle that a party does not need to give evidence. We are not contesting that principle. It's trite. You come to court and you decide how you do your case. We don't have a problem with that. Everybody knows that.
You said that very early in your submission.
Yes, so I'm saying that when it comes to a witness and how a witness should be treated, I'm saying that in respect of that, if that witness is conclusively presumed to have put herself forward for cross-examination, that witness ought to be made to testify. That is my submission. So, my lords, respectfully, the authorities that are cited including armor and hydrofoam, which again, a court has no duty to call upon any party to testify. None of those matters is in contest in the circumstances of this case. What is in contest relates purely to a witness who has put herself under a conclusive presumption that she is offering herself for cross-examination. And the circumstances in which she did that are very critical for this court to appreciate, because the circumstances were where we sought, by way of interrogatories, we sought to have her answer some very simple, straightforward questions, and she would not answer. We sought leave from this court. And this, in the context of the leave that we sought, she deposes to an affidavit saying that we are not going to be prejudiced by her not having to answer the interrogatories. We are not going to be prejudiced because you can by my not answering the interrogation. Examine me. Those are words that she cannot run away from. Those are her words. And so my words.
So I want to brought back home. Clear. Now, I'm placing a witness in a distinct position from the party who intended to call that witness. But what I know is that it is a party who calls a witness. So if a party says, I'm not going to call my witness anymore, can you say, no, since the witness has proposed to an witness statement, that witness must be called by all means. The party who wants that witness to support him says, I'm not calling that witness anymore. I want to be very clear.
Yes, if the interests of justice demand that. Of justice.
Order in court, please.
If
order.
The interests of justice demand that. There are many justices of the Supreme Court in the room. But, my lords, if the interests of justice demand that witness.
He's responding to a
My Lord, I don't understand these tactics because it's not fair. My Lords, I move to ground E.
Is that the last one?
No, the last but one.
10 minutes only.
My Lord's, ground E is where we say that the court fundamentally erred in putting forward positions which were not what counsel for respondents put before the court in respect of the case, thus occasioning a grave miscarriage of justice. Now, my Lords, the error that we refer to here is related to the reliance that your lordships place, and that came from some questions from the bench as well, on order 38, rule 3E1 of CI 47 as amended by CI 87.
Now, my lords, Rule 38 3E5 is what was relied on by counsel for the first respondent initially. Now, in the course of my submission, reference was made to Rule 38 3E1. Now, this does not appear to be denied in the submissions of respondents. What they appear to be saying is that 3E1 is a matter of law. And your lordships will recall that, well, I shouldn't say your lordships will recall, because this is a bench that is different from the bench before whom we made the initial arguments. But, my lords, in respect of 38 3E1, the reference to that order was first from the bench. And the response that I gave to that was precisely to point out that under the terms of that order, if the first respondent no longer wished to rely on that witness statement, that needed to be made clear. Because under the terms of that order, if the first respondent now decided on a different conduct of their case, which they are of course entitled to, if they did that, then it effectively would mean that some decision needs to be made about the witness statement that they have filed. Because, my lord, in ruling, for instance, in ruling that they are allowed not to testify, nothing has been said about that witness statement. That witness statement is still a matter of record. That witness statement has not been expunged. That witness statement is still a witness statement for whatever it is worth on the records. And, my lords, it is our respectful submission that if the first respondent did not wish to abide by that witness statement, they needed to make that clear to the court. And your lordships, in the course of argument, ask, can that not be implied? And, my lords, my respectful answer is that a matter of such magnitude ought not to be left to implication, because they were putting something forward to the court on the basis of which they wanted the court to take certain steps. And it was incumbent on them to put forward exactly the status of that witness statement. As things stand now,
That witness statement is hanging in the atmosphere in some fashion. And it is our respectful submission that the operation of Order 38.3E1 cannot just be a matter of implication. The respondents made specific proposals to the court, and those proposals did not include a reference to Order 38.3E1. In fact, the order that they relied on fundamentally, that order was Order 36, Rule 4.3. And your lordships, respectfully, your lordships left that order aside in one breath, but it would appear that when your lordship subsequently made orders, that rule which they themselves had cited, which relates to the fact that if they take the decision that they take, they then have to be called upon to state their case first before we are called upon. But when your lordship subsequently made orders, your lordships called for simultaneous filing of written addresses, even though Order 36, Rule 4.3 is quite clear, and they relied on it, they put it forward to you. That order is quite clear that if they take the steps that they say they are taking, and if they are interpreted as electing not to adduce evidence, then a certain process follows. So if that is the case, then, my lords, it becomes rather baffling that once your lordship set aside that order in dealing with this ruling, your lordship subsequently disregarded that order in the orders that you made regarding the process. Now, my lords, I conclude with the last ground, ground C. And that ground indicates that the ruling of the court was in breach of Article 1913 and 296 of the Constitution and has occasioned a grave miscarriage of justice. Article 1913 simply reads as follows: an adjudicating authority for the determination of the existence or extent of a civil right or obligation shall, subject to the provisions of this Constitution, shall be established by law and shall be independent and impartial. And where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. A fair hearing is the emphasis. And we are submitting that there was a denial of a fair hearing in the ruling that your lordships gave. There was a denial of a fair hearing because both the statutes, the legal authorities, and the factors of discretion that we put before your lordships demanded a ruling other than what your lordships ruled. The statutes, being Section 26 of the Evidence Act.
Mr. Chigata, your time is up.
Very well. Article 296 is the final article I was referring to. Very well.
My lords, we are opposed to the application hearing. We rely on our affidavit in opposition and the statement of case that we have filed. My lords, we also rely on section 54 of CI 16. Sorry, my lord, rule 54, my lord, rule 54 of CI 16. Sorry. And submit that there has been no, yes, my lord, Supreme Court rules CI 16 of 1996 as amended. Lord, it's a submission that there has been no fundamental errors of law which have occasioned a miscarriage of justice or constitute exceptional circumstances to warrant this court reviewing its decision of 11 February 2021. Lords, in the ruling of 11 February 2021, your lordships ruled that the applications in respect of which the affidavits were filed have been determined. Now, my lords, reliance is being placed on section 26 of the Evidence Act, and that representations have been made in those affidavits to the petitioner. Lords, we need to bear sight of the fact that there is a second part of section 26, assuming that there are even representations made. What reliance did the petitioner place on those representations? My lords, the petitioner filed this application for interrogatories and argued it fully in spite of those depositions. When the court ruled against the petitioner, he filed a review and argued it fully. The petitioner again filed an application for inspection of documents, pursued it fully. My lords, is it the case that we are saying that the reliance that the petitioner placed on those depositions was that he argued the cases to the end? I don't see how somebody who has placed reliance on certain set of facts will now claim that as a result of the reliance I placed on the depositions you made, that is why I now want to cross-examine you. When indeed his reliance he placed on those depositions was to pursue his application to the end. We are not in a situation, my lords, where the petitioner is saying that as soon as he saw those depositions, he told the court, my lords, in view of paragraph A, B, C, or 1, 2, 3 in the affidavit in proposition, I will not pursue the matter. I will await the time when the chairperson enters the witness box or whatsoever. So, my lords, it's our submission that reliance which is being placed on section 26 of the Evidence Act is misconceived. My lords, it's our further submission that the arguments made and the authorities cited in the analysis being made regarding the ruling of 11th February 2021, we have all heard. The arguments are the same. The citations are the same. Lord, there has been no new ground that has been urged on this honorable court for which the court is being invited to review its decision. Lords, I'll refer your lordships to the case of Charles Lawrence Quist versus Ahmed Dawouni. Review motion number J7/8/2015, dated 5th November. Yes, my lord. Yes. So, my lord, I will end my submissions by saying that an application for review is not an opportunity given to a party to have a second bite of the cherry. The Supreme Court cannot sit in judgment over itself as if it was determining an appeal. I pray that this application be dismissed.
My lords, we are opposed to the application for review, and we rely on our affidavit in opposition and statement of case filed on the 17th of February. My lords, it is our respectful view that this application does not appropriately invoke the special review jurisdiction of the court under Article 133, as well as Rule 54 of CI 16. My lords, we are submitting to this honorable court that this application is a classic case of an aggrieved party who has become emotional by the decision of the court, seeks to re-argue its case through the back door of an apparently review application, which it is not. And for these reasons, my lords, the application ought to be dismissed. But we would like to make a few other points. My lords, counsel has referred to Section 26 of the Evidence Act. And whenever he does so, he fails to recognize that that section is subject to any other law or rules of equity. And my lords, in our view, Order 38, Rule 3E is any other law. So this is not a situation where you can argue that you are using a subsidiary legislation to trump a substantive legislation, because if one goes to Article 11 of the Constitution, which defines the laws of Ghana, it includes subsidiary legislation. Now, my lords, again, the petitioner cannot seek refuge, even if it is true, in the fact that the application was argued not on grounds 38. Why? Because before the court, there was extensive argument on that order. 38 rule, sorry, order 38. There was extensive argument on both sides, including questions by the bench. So it does not lie in his mouth now, after the fact, to suggest he couldn't be suggesting that he was taken by surprise. He had every opportunity to advance his arguments. We also advanced our arguments, showing how circular his arguments were and how completely misconstrued his attempt at interpreting the various sub-rules under Order 38, Rule 3E was. So, my lords, it is our submission that this court is entitled to ignore all the arguments that have been advanced today in respect of the correctness or otherwise of the use of Order 38, Rule 3E. Then again, my lords, we do not see the relevance whatsoever of a reference here to Article 19.3 of the Constitution, which is a criminal matter, deals with criminal matters, and also Article 296. My lords,
Actually, I did not refer to Article 19.3. I referred to Article 19.13.
Very well. My lords, I'm sorry. My lords, my other point here is that now a major foundation of this application is the interest of justice. My lords, we all know that when courts rule based on the interest of justice, it's not at large. It is in reference to the specific circumstances of each case. So, my lords, it cannot be that the interest of justice is a ratio. I mean, it cannot be.
To the Article 19, Clause 13.
No, I've moved from that.
Yeah, okay. Oh, yeah. Carry on.
Yes. My lords, I'm saying that one cannot use the interest of justice as declared by a court in a particular case as a general magic wand. You know, any case, you say that, oh, in that case, by the interest of justice, which was the ratio, should apply there. It cannot be so. Every articulation of a decision based on the interest of justice is grounded on the specific facts as assessed by that particular court. And this court, or the ordinary bench, had assessed the facts of this case and did not find that there was any compelling interest of justice for it to grant the application being sought. And my lords, this is so, in my view, respectfully, because this whole case is based on a fiction. It's based on a fiction. No, the whole case. Now, which this is a subset. Yes, the petition is hold based on a fiction.
It's at the tail end of your.
No, my lord, it's relevant.
No, please, we are dealing with this application for review.
But the application
so
for
he has argued at length. We extended time for him. So take your time. Don't go to the substantive matter. Yes, we have given a ruling, and they are seeking a review.
Yes.
Yes.
So, my lords, I believe and we submit that this application is completely unmeritorious and does not satisfy the very strict conditions for review laid out in Article 133 of the Constitution and Rule 54 of this court's rules. We accordingly pray that this application be dismissed as an abuse of court process. And even though we are all aware that in constitutional matters like this, no costs are awarded, I think this is a proper occasion.
Is this a constitutional matter?
Yes, it is. More or less. It's a special jurisdiction under the Constitution. Yes. So, and if it isn't, more so, why costs should be awarded.
Mr. Kotuapa, I'm interested in why you permitted Mr. Kweku Asrifi to swear, to depose to the affidavit in opposition on behalf of the second respondent when he is not on record as the attorney for the second respondent. What we have on record is that Mr. Kweku Asrifi is one of the counsel announced in this case. Is there any justification why?
Yes, my lords. The attorney has powers to testify.
There are factual matters that has been deposed to. We have been told that one Peter McMenu is the attorney for the second respondent.
Oh, relax.
Well, from these parties where lawyers who are engaged by parties take it upon themselves to depose to affidavit when the parties are there. Can you justify it?
My lords, as I've indicated, lawyers take instructions from their client. Our client is the second respondent. Mr. McMenu was given a power of attorney to go into the witness box if necessary to testify. So that is the distinction.
And he has given power of attorney to...
No. My lord, you seem not to understand me. The attorney, power of attorney, was simply for him to go into the witness box in relation to his witness statement.
So when an affidavit will have to be sworn to, who is it lawyers who swear affidavits on behalf of clients?
Well, my lords, in circumstances like this, I believe that it is in order and permissible for lawyers to swear to affidavits.
Very well.
Yes.
Lords, respectfully, if with your leave, I may just make two quick points, because reference was made by my learned friend to the first words of Section 26, except as otherwise provided by law. And my learned friend made that reference in order to suggest that perhaps there is some other law that enables 36 to be put out of court. Well, my lords, our ground is that your lordship's decision respectfully was per incuriam of Section 26. It's not as if your lordships adverted to Section 26 and then said that because of some other law
we are not going to apply. That's not what happened. Your Lordship didn't admit to it. Now, and it's quite clear in their opposition. It's quite clear that that's what happened, because they then tried to use your Lordship's ruling on the 16th of February. They tried to use that.
My lords, we have not tried to use that. So my counsel should not refer in responding to my submissions that they have used it. We have not made any such reference in our affidavit.
There's such a unity of purpose.
There isn't. We are different parties.
And my Lord, my only other point by way of response is that counsel for the first respondent asked, what reliance did we place on the depositions that were made? Evidently, we relied on that to close our case, as we did. Because, my Lord,
is it a point of law?
I'm sorry.
Is it a point of law?
I'm sorry.
Is it a point of law?
Is it a point of law?
Yeah, what do you want to respond
Well, my lords, the issue was really whether we had relied on it. That's a point of law, whether they had been relying, because they're saying that.
It's a matter of fact.
It's a matter of fact. That's fact.
It's not.
I think, my lords, so my lords, on what evidence are your lordship going to? No, on what evidence are your lordship?
Order.
Respectfully, then the question on what evidence are your lordships going to determine that matter of fact? My lord, respectfully, this, I think, is an appropriate situation where it's really a mixed question. It's a mixed law, in fact, because he is saying that legally, the reliance on the deposition is part of what kicks in Section 26. And my point is that, yes, in reliance on that deposition, we close our case. I mean, we made that evidently clear in this court, because
so you've made this point. Their view is that you did not rely on it because you pursued those applications. Your view is that you relied on it, and it's on that basis that you closed the case. So we have heard both of you.
It is not just my view, because the question whether we relied on it really lies within our courts, much more than their speculation. Because nobody can speculate in terms of the conduct of our case. The conduct of our case, as we had it, relied on, because when you come to court, you rely on what comes to you from the other side as well. So, my lords, we clearly relied on that conduct. And our main submission on that Section 26 is that your lordships did not advert to that, much less try to
you realize
qualify.
that you did not, in your submission on that day, you never referred to Section 26. On submission, during your submission.
My lord, on that day, your lordship asked me, is it an estoppel argument?
No,
and I said, yes.
No, that was the answer. You did not refer to as Section 26. Section 26 are coming to play in these proceedings during the last argument. That was when you relied on, because I've looked at the proceedings of the 9th February.
Yes, my lord, I did not refer to Section 26 on that occasion because, my lords, the question about estoppel, your lordship asked me, and I said, yes, it was estoppel. I did not refer to Section 26, but that's a matter of...
The question about estoppel was asked during the last...
Your lordship asked me the question about estoppel during the transcript.
That is what caused you to write to us, that you needed to give further submissions.
No, my lords, respectfully, my lords, no, that is not, respectfully, that is not the case. The transcripts are very clear, respectfully. Lords,
I have a question.
Yes.
I have a question. My question is, these affidavits were they not sworn to before the trial, before the hearing? They were sworn to during the interlocutory application.
My lords, affidavit sworn to during...
No, I'm just asking a question. Were they not sworn to before you put your witnesses in for hearing?
Yes, they were.
Thank you.
And my lords, that has no significance for the reliance. It has no significance for the reliance that we placed on it in the conduct of our case. Because your lordships will...
Be satisfied with your answer.
Well, you can't be satisfied with your answer.
Order.
Yes.
Order, please.
My lord, you can't be satisfied when I have not completed my answer.
Order in court, please.
I've not completed my answer and your lordship says I'm satisfied with your answer. You're cutting me short in giving an answer that will address what underlies your question, because what underlies your... If my lady can allow me...
Just a minute. Respectfully, Mr. Chikata, these are matters of fact. The date on which the affidavits were filed, the date on which the trial was conducted, these are matters of fact. So I could even come to that, I could do that evaluation without asking you a question. I chose to ask you the question so that you could avert your mind and confirm. That is all.
Yes, but
so in answering my question,
so may I complete my answer?
Very well, Mr.
Because, my lord, when affidavits are sworn to in interlocutory proceedings, in the course of a trial, it is open, for instance, to put the matters that were deposed to in an affidavit in an interlocutory proceeding to the witness when he enters the witness box, and to put before them, didn't you say this on oath in an affidavit before this court? This is a matter that is quite basic in the practice that I'm familiar with, that when you have an affidavit sworn on oath in interlocutory proceedings and a witness comes into the witness box to testify, that affidavit can always be put to them in terms of the veracity of the things that they stated. So you can't say that just because this was done in the course of interlocutory proceedings that were before the trial itself, they have no bearing on the conduct of our case. Because my lord will recall, my lady will recall, that this whole matter of crossing that bridge when we get there was in terms of whether cross-examination would provide an opportunity for those matters to be addressed. And your lordships, one or two of your ladyships, put across the perspective that shouldn't we be waiting until cross-examination before we address those matters? And indeed, that is precisely what we did, because your lordships ruled against us, so we had to wait for the cross-examination to take place. And we waited on the basis of sworn affidavit by the chairperson of the first respondent.
Please, the court will rise to consider its ruling.
All right.